I feel like I shouldn't be in the middle.
Yeah, I guess so.
Hello, everybody. My name is Warren Lipschitz. I'm a principal at McKool Smith, and I have spent most of my career litigating FRAND-related issues. I am honored to be here today to cover this topic at our conference, and it's an important one. The question before this panel is, what is the global impact of standardization law? And as P. Diddy said, it's all about the Benjamins. Right? By that, I mean patent royalties. The law can make the royalties go way up or way down. And relevant to this panel, a decision by a court in one country can make worldwide royalties go up or down. And that can have a major impact on the industry. Today, participation and competition in standard setting is at an all-time high. There are more companies than ever, for example, in the cellular standards, competing to get their patented ideas into the standard. And this competition has resulted in huge improvements in performance. We've gone from less than 1 megabit per second in 3G to hundreds or even thousands of megabits per second in 5G. And it's because of the technology invested in and developed during standard setting. Now, what happens if the courts in one country, like China, for example, decide that the total royalties to be shared among all standard participants should be cut by 90%? What would that 90% reduction in royalties do to participation and investment in the standard? And this is not theoretical, and it's not an issue that's limited to China. What if the US courts decide, as some implementers have argued, that SSPPU should be the law of the land for SEPs, and thus the entire royalty stack for the entire cellular standards should be $1. A $1 royalty to be shared between everybody participating in the standard. Based on some estimates, that would be a 90% reduction in royalties. And that's something that one court can do that could have an impact on the entire worldwide investment in standardization. And so the first question I'm going to ask this panel today in a couple of minutes is whether they agree with that. Can a single country have that big an impact on the investment in the standard? But before we do that, let me introduce them. We have a great panel here today to help us tackle this issue. Next to me is Tim Syrett, partner at WilmerHale. He's represented some of the biggest implementers in the world in their FRAND-related disputes. Next to Tim, we have Joseph Matal, partner at Haynes Boone, former acting director and solicitor in the United States Patent Office. Next, we have Kjelland, vice president, legal counsel at Qualcomm, one of the largest implementers and licensors of SEPs in the world. And finally, we have Justus Baron, professor at my alma mater, Northwestern University. So let's start here. This is a question for anybody on the panel. Do you believe that the courts in one country can have a significant impact on patent royalties worldwide, for better or worse? I want to pick on somebody if nobody jumps in.
I'm happy to kick it off. I think there's a potential for that, but based on what we've seen so far, I'm not sure that's really been the case. There have been obviously a number of decisions about setting RAND or FRAND royalties. I think they give useful guidance to people in the ecosystem about what they can expect when they go to court, which is kind of, you're obviously negotiating in the shadow of the law, and so you need to know how a court is going to think about it, and we've gotten insights there. I'm not sure, though, absent some kind of unusual circumstances, that the decision of one court is really going to have such a significant impact. I think we've seen courts jockeying for, to attract litigation on these issues, and so I think there's probably going to remain competition between courts. And so I think if one court were to swing very far in one direction, you'd see likely a reaction from others, as I think we've seen in terms of the adjudication of global disputes.
Justus, what do you think?
I mean, I generally agree. It's easy to see that there's a potential for court decisions to shape licensing negotiations and the rates. I think that it's a little bit over time, the issues have settled and we are getting more incremental in terms of the things that are open. So I think that 10 years ago, there were these fundamental court decisions, the first rate determinations. I think they had a huge impact on people's perceptions of what a FRAND rate is. I think that the potential for a single decision to have that impact today is probably a little bit reduced by now. But
well, do you think SSPPU is a settled issue?
Well, I think there is, I'm not sure it's a consensus, but I think there is a majority view emerging that it can be a benchmark, that it can be one reference point, that it's not an exclusive benchmark. So I think most people would agree that there are circumstances in which you can refer to an SSPPU. There are many people who agree that there are other ways of making a determination of a FRAND rate is, and I think then we are talking about, okay, in what circumstances is a particular methodology for rate determination appropriate, a violation of the evidentiary rules on the SSPPU. So I think it's, even on that issue, we're approaching a point where disagreement becomes more incremental and marginal. It's my perception.
Kurt, do you think there's a general consensus around SSPPU being a good data point?
I don't think there's a consensus, and I think the cases are kind of all over the map. I do think the doctrine's been misconstrued from when it first got enunciated and then incorporated into the sort of SEP body of cases in Erickson v. D-Link. I do think that the courts are scrutinizing the evidence that you put forward. They're not going to necessarily default to SSPPU. I also think that when you look at the doctrine, you got to place it in context. There's two types of SEP disputes. One where the SEP has never been litigated before, and then you're looking at a green field of how you're going to analyze the damages. Then there's others where there's well-established license agreements, for example, that document what the value of the patent is. And in those cases, I think that the SSPPU doctrine should not apply at all. Because you're looking at what the comparable licenses are, which are, by any measure, the best way to value patents and litigation.
So then do you think any courts in particular have pushed royalties up or down, or do you think in general the courts have pretty much maintained a status quo when it comes to SEP royalties? Joseph, sure.
Probably the most kind of interesting and frankly disturbing development has been just in the last couple of years, courts, assuming the jurisdiction to set royalties on a global scale. This was just unheard of 5 years ago, and after the UK courts started to do it, it's inevitable others follow in its wake, and maybe we haven't seen the impact yet, and I hate to be the prophet of doom and gloom, but this is a bad trend. Especially the fact that the Chinese courts have really gone down this path. Look, China's a very mercantilist, nationalist government where every level of the government works to advance their national interests at the expense of everyone else. When you have these US companies getting pulled into a global rate setting that includes US patents, there's no reasonable expectation they're going to get a fair shake. And if you look at the way some of these proceedings in China are conducted, things are done ex parte. You're not even told you're pulled into one of these things. Then you start getting hit with injunctions, unpublished decisions. They start to invoke their anti-monopoly law if you're deemed not to be negotiating fairly with a Chinese company. And again, like all parts of the government, the courts aren't independent there. The agency isn't independent. They all serve the same mission. And we already see some of this just in data about licensing. China's responsible for about 22% of electronics products sold around the globe, and they pay about 6% of US licensing fees. A non-transparent, nationally run system like this isn't going to be good for any U.S. interests, and we're just starting down this path. I tremble to think what things are going to look like a decade from now if we continue along this route.
And so we've got Tim here, who often represents implementers. We've got Kurt with Qualcomm, who's a licensor of patents. I'm curious, do either one of you think that a court, like the courts in China, should be able to take exclusive jurisdiction over a FRAND dispute without consent of the parties?
I think it probably depends on the situation. I think if the licensee takes the licensor to court and is alleging a breach of contract, and the contract law allows for specific performance, then I think that's what the licensor has signed up for, to license on FRAND terms. And if the court is able to reach a determination about what those terms should be, then it follows that they could enforce those terms. I think it's a different situation if it's the licensor trying to take the licensee to court and have one court adjudicate global terms for patents without findings of infringement. Obviously, they can't adjudicate foreign patents. They, practically speaking, won't be able to make findings of infringement of all of even the national patents. That, to me, I think they're different situations, and I think the situation like Unwired Planet is troubling. That one court, with relatively little linkage to the dispute, a Chinese company and an American-based company is deciding global terms and imposing them through the threat of injunction.
So as I understand that, what you're saying is that you need the consent of the implementer, but you don't need the consent of the patent holders.
Well, and again, obviously it depends on the law that applies, but I could foresee situations where I would say the licensor has already given its consent to license on FRAND terms, right? And that the licensee is simply asking the court to have the licensor live up to that commitment. I think it's a different situation with the licensee, which has the option to benefit from the FRAND commitment that the licensor has made, but it itself has not made its own contractual obligation that it's going to license the licensor's patents necessarily. Now, obviously, if the licensee doesn't engage in licensing or doesn't get a license, it leaves itself open to infringement suits and the rest of it. But I don't think there's kind of the same contractual obligation on the licensee as there is on the licensor.
What do others think about that?
I think that, again, you have to look at the context of it. And, just having a straight rate setting exercise, a court say, someone bring a dispute and say, I want to, assess the rates for these patents or this portfolio, is not what the paradigm is under FRAND. I think all these disputes come about because a licensor has made an offer that they typically believe is FRAND, and the licensee disputes it. And really the fundamental question that should be litigated, but sometimes is not, is, was the licensor's offer FRAND? If it was, it's discharged its duty under the FRAND obligation, and that should be the end of the dispute. It's not an exercise, where I've made a FRAND offer as a licensor, for example, and you just think that you should, implement whatever the implementer's offer is, and then you just decide what's FRAND. Okay, that's not the first order analysis that needs to be made, and I think that point's often lost. Especially if you look at what Tim's articulating, which is the implementer has no obligation under the FRAND paradigm to accept a license or to be brought into court to set a global FRAND rate. So I do think there's some tension there in how you look at it, and I think it's just the key thing to decide is whether the innovator or the patentee's offer was FRAND, and that's where you need to look first.
Joseph?
Yeah, my sense of this is, studying these issues is just U.S. law really isn't set up to deal with these issues. There's basically no mechanism for a patent owner to get a global rate. There's no theory or any cause of action. The one that's sometimes worked, and increasingly less so for licensees, is the state law, common law cause of action for breach of contract. You entered this FRAND agreement, I'm a third-party beneficiary. That sometimes worked. Lately, it seems not to be working. And even when it does work, it's just strange. It's these are patents that are issued by the U.S. government over which there's otherwise exclusive jurisdiction in court, and it's just strange to have these issues litigated as a state law issue, or even if you go to federal court, it goes to a regional court of appeals. Those courts clearly seem uncomfortable with this. And then lately, people have even been bringing these actions in state court. Why not? It's a state law cause of action. Our mechanisms for resolving these disputes are still basically the same ones we had in the late 19th, early 20th century. And we've never created a system for adjudicating these, determining, I think the determination of what's FRAND is going to end up pretty closely matching the question of reasonable royalty. There's all kinds of law and theories about that. The substantive law, is pretty settled, but there's no mechanism for resolving these disputes right now. And frankly, that's part of the reason I think we're losing jurisdiction over these things to foreign countries. People want some kind of a resolution, and you can't get the resolution in the United States right now.
Justus, do you think that there are better mechanisms outside the U.S. to deal with these issues?
In general, I'm quite a big fan of the German jurisprudence on these issues. I think that there are certain considerations. I think the first consideration is that, in general, it's the SEP owner's responsibility to ensure consistency of licensing offers made to different parties. So that makes it kind of difficult to say, okay, when the SEP owner has to engage with the licensee's licensing offer no matter what. I think that when the SEP owner formulates a licensing offer, and there's a determination made that the licensing offer is FRAND, then I think that there's an obligation for the licensee to accept that licensing offer. That's the first consideration. And then the second consideration is that determining what is FRAND independently of a market process, independently of a negotiation taking place in a competitive market is very difficult. And therefore, I'm a little bit concerned about these different countries' courts racing to be the one to set and determine FRAND rates. And I think that the alternative approach to basically keep parties engaged in the negotiation process as long as possible and forcing parties to cooperate in good faith with that process is, for an economist, a more attractive and viable alternative. And I think that, by and large, that's a process that has theoretical strength, but I also think that in practice it seems to be working in terms of creating incentives for people to stay engaged in market-based forms of determination of FRAND rates.
Sure, Joe.
One more thing. The other thing about this global adjudication is this is never going to happen in the U.S. U.S. courts will never assume this kind of jurisdiction. There's just too strong of a legal culture here of strict limits on jurisdiction. The current Supreme Court, the court's been pretty hesitant to sua sponte creating new causes of action for a while. That's only going to be more so. I don't see the U.S. federal courts, especially the Supreme Court, ever blessing a system where we just invent some new cause of action that allows foreign patents to be adjudicated in the U.S. So you're not going to get a solution to this in the courts. And as more and more foreign countries are willing to do this, we do face the prospect of losing control over the adjudication of our own patents and licensing fees in this country.
I actually disagree with that, and here's why. I think that we have to contextualize this again with, the whole idea of a standard is to have a global standard, a global technology standard. And what throws a wrench in the spokes, if you will, is the fact that patents are national rights. And so we sometimes will have different legal paradigms that may adjudicate an individual patent. But what was done in Unwired Planet was say, look, okay, I'm not going to evaluate whether a license rate on a patent-by-patent basis is FRAND or not. The patent owner satisfies, its obligation to make a FRAND offer if it does it on a portfolio level. And if you, as the implementer, don't want to take that license at those rates worldwide, then you have the potential of being enjoined in that country under those national rights. And I think that there's no reason a similar like dispute could not be adjudicated in the U.S. courts, where there's a global FRAND offer being made. It's not accepted, and so the patentee has no choice but to start bringing patent lawsuits against the implementer. And then that can be looked at under U.S. law and under whether an injunction should be granted, because at that point the implementer is a unwilling licensee by not accepting the global FRAND rate. And if they're found unwilling, then they're at risk of getting an injunction entered into. And that's what really would look to resolve these things. So I think sometimes the headline of setting a global FRAND rate, it takes precedence over really what's happening here. That the licensee is potentially, the unwilling licensee is not willing to take a license under the global portfolio to implement global technology standards.
So Tim, what do you think about that? I mean, if you get a decision that an offer from the patent holder was FRAND, what's wrong with an injunction?
Well, I think in the United States we have eBay, which is going to take into consideration more factors than just the willingness. If there's a path to FRAND royalties on particular patents through infringement suits, then I don't think you would satisfy eBay. I'm not sure that I think there's general agreement, maybe not universal, but general agreement that FRAND can be arranged, that when two parties sit down to negotiate a license, they're not necessarily, there's not one specific rate that's always going to be FRAND. So you could have differing views, and it does seem like you're putting too much power in the hands of the licensor to be able to say, this is the one rate I believe is FRAND. If you don't believe it, if you don't agree, even if you are engaging in good faith, you make what is truly a FRAND offer and you want to reach an agreement, but because you haven't accepted what the licensor has come forward with, that you are at risk of injunction, that to me is troubling, because you've signed up to accept FRAND royalties, and if someone is offering FRAND royalties, you are getting the benefit of the bargain you agreed to, and therefore I don't see the need or the justification for an injunction in that situation.
Why does the patent holder have to go any lower than the top of the FRAND range? If this is a contract that says you're willing to license your patents on FRAND terms, and they make an offer that's FRAND, why do they have to do better than that?
Well, I guess I'd turn it around. Why is the licensee forced to accept the top? Why can't there be some bargaining, as it is in a normal commercial situation, where both sides will come to the table and have to give ground a little bit? I think you've signed up for FRAND, but it can be arranged, and therefore I think it's reasonable for one side to say, here's my counteroffer, here's where I think it should fall in the range. And they can have a dispute about that, obviously, but I think if you arm one side with the ability to get an injunction just because there's a good faith dispute, it is tipping the scales, it is allowing the patent holder to use the holdup power that's come through standardization to obtain royalties that, even if they're FRAND, they're depriving the licensee of the right to negotiate.
What do you guys think about that?
I'll just add that what's FRAND is often in the eye of the beholder. When you begin with the premise that, well, this offer is FRAND, and so shouldn't they accept it? Well, you're really saying, hurry up and agree with my premise. There's often a lot of very vigorous disagreement about what's even within the range of FRAND. And when you follow some of these cases, for example, that have been adjudicated in the US as the third-party beneficiary contract action, the initial offer that was offered as the FRAND offer often ends up being several orders of magnitude greater than what the court ultimately adjudicates as a reasonable royalty. The parties don't just agree on what's FRAND, and sometimes you do need a dispute resolution mechanism to resolve that.
And so, Tim, I think you were referring to the situation where maybe two offers, they're both in the range. Maybe they're relatively close to each other. Oftentimes, they're nowhere close to each other, right? Where somebody's arguing, the royalty should be $2.50, and the other side's arguing it should be 10 cents. If there's a finding that the patent holder's offer was FRAND and the other party is unwilling, do you then agree that an injunction is appropriate?
In the United States, no. I think it would, well, it might be, but I think it would depend on, I think you'd have to apply all of the eBay factors. And I think the unwillingness just goes to the issue of, can the licensor obtain the FRAND royalties? If it can still obtain them as a matter of damages, then I think that path is still there, and you need to look at the eBay factors in totality, and it seems unlikely that you would be able to show irreparable harm and that an injunction should issue.
What about the ITC?
Well, I think the ITC is a different story. Obviously, they don't follow eBay, and they kind of have one tool, and that's an exclusion order. So I'm not sure the ITC should be in the business of figuring out what a FRAND rate is between parties. I'm not sure they have the institutional experience to do that. It's obviously a complicated question, and they obviously have the mandate to consider the public interest factors, where I think FRAND can factor in, although it seems like it tends to get short shrift in that analysis. But I do think it sends a message. If a party is really willing to negotiate, willing to come to terms, and there's a good faith dispute, and an exclusion order issues, it suggests that the patent holder does have a lot of leverage, and I think that sends a discouraging message to others that they really don't have the opportunity to negotiate in good faith, that they have to take the offer. And to pick up on Joseph's point, I very much agree. What is FRAND is a very tricky question to get to, and what you see a lot of times is that licensors will establish a licensing program, and they'll find some companies that will agree to the rate. They may not have the incentives to dispute it, to the willingness to go to court, or the sophistication to understand that what's being asked of them is not FRAND. And then the licensor will try to move that rate over to other people who maybe have more sophistication or in a different situation, and say, well, I have these 5 people who are paying it, you should too. And I'm not sure, I think that's too simple a test. I think people can be differently situated, and that needs to get taken into account as well.
So Kurt, what do you think about the ability of patent holders to leverage a FRAND agreement if they didn't have the injunction?
Say that again?
Do you think that patent holders would be able to leverage or create or incentivize a implementer to take a FRAND license if they did not have the threat of an injunction?
Well, maybe that's just the wrong way to think about it. I definitely agree that you will incentivize holdout behavior if an injunction is not available. And in some respects, what Tim was describing, I would characterize as holdout behavior, in the sense that, if you have the licensor's made a FRAND offer, and meaning it's discharged its FRAND commitment, and the licensee says, well, but you know what, I want to go through litigation, I want to get a trial, and what I'm offering is FRAND too, and we should, adjudicate that issue. I think that's just another way to describe holdout behavior, because you're not going to get to an agreement if you're going to incentivize people to be characterized as willing when they're unwilling to take a FRAND offer. And that's what the argument is, at least as I'm analyzing it right now. And so without an injunction against an unwilling licensee, meaning a licensee who is not willing to accept a FRAND offer that's been made, all you're going to do is incentivize holdout in the system and drive royalties down. And I can't see it any other way. So, I think that maybe that's, my response to your question there, Warren.
Justus, what are your thoughts on that?
Yeah, I generally agree. I think that if you completely take the injunction off the table, it's difficult to see what the rationale would be for bilateral negotiations to be successful. I mean, you obviously can have a system where there are damages that are so significantly enhanced that they, in practical terms, have the same effect as an injunction. But that kind of already presupposes that the court knows what the damages should be before being able to make that determination by how much to enhance these damages. So I think that given that in practical terms these things become equivalent once these damages are sufficiently enhanced to create this incentive, then I think the injunction is just the clearer solution. It's cleaner, it's more clearly related to the market value that is enabled by the patented technology. So I think that both on practical and theoretical grounds, then the injunction just seems the preferable option. It's clear that this leverage that the injunction gives can be excessive if there is no meaningful test of the patent holder's compliance with the obligations. So I think that this is a concern that is often raised, and it's clear that the case law needs to develop and there needs to be a meaningful test of compliance with these obligations. But I think that the German case law provides evidence that courts are capable of doing that. I think that if you look at the decisions, I think that it's roughly half split between the cases that end up in an injunction and those that end up with the injunction being denied because of failure to comply with FRAND obligations. So I think it's clear that there's a meaningful test of this compliance with these obligations being applied, and that this results in people really becoming careful about the way they engage in negotiations, and people being careful not to let too much time slip after receiving a certain type of letter, because courts have said, like, after 2 or 3 months, then you're already facing a situation in which the court would no longer hear the other arguments, because like it's clear that you have demonstrated unwillingness to be supportive of this negotiation process. And I think that this is the right way to go.
So I do feel compelled to add, I've talked to companies who have recently experienced the German injunction, and they were not pleased with the system.
Yeah, I can imagine.
They didn't feel the offer they were given was FRAND, and in fact they felt like, I've talked to people who feel like they were, you're basically told like you either agree to what's being offered right now or we're issuing an injunction and shutting down your production line. And I've talked to people who've, like, they were forced to license patents they were pretty sure they were already licensed for, and they have no idea where the numbers come from. There are people who are not thrilled with the resort to the injunction as a remedy. It's just, again, like it all presupposes, is the offer FRAND or not? And in a lot of cases, the parties will just be far apart, and you need some system of resolving it. I will add too that the current system is hard on patent owners, especially smaller patent owners. It's these standards have spread. It's become just monstrously difficult to enforce a standard against an industry, and you do see people who just don't even bother to get in the game. You need such a massive litigation budget. If you look at the first business review letter that the Justice Department did for, I think, like MPEG, they did a search for all the patents that are going to apply, and it was 28 patents. And boy, to go back to an era when things were so simple, they currently estimate that there are about 100,000 patents and applications that have been asserted as essential to 5G. And just the thought of, like, obviously there needs to be some kind of sorting mechanism. If you said everyone, we're just going to divide up the pie among all 100,000 patents, everything that uses 5G connectivity, we'll just pay 1 penny for each of those patents. That'd be $1,000 in licensing fees for each product. There just needs to be some system for sorting through this, and ideally something that just isn't so massively expensive, and that lets holders of small but valuable portfolios still get their foot in the door.
So let's talk about that. That's something that's commonly argued, I think, by implementers, is the fear of the royalty stack. That if this is what we have to pay one company for their patents, we're going to have to pay hundreds of dollars or even $1,000 for the royalties for all the patents. And I'm wondering, Justus, you do empirical research. Have you seen any evidence to support that argument?
One difficulty in that space is that the data on licensing, and especially the data on the rates that companies are paying, is just so limited. So it would be really difficult to actually make an empirical assessment what companies are actually paying for their products. There's work which I think is relevant that looks at the total royalty flows in the industry and compares or relates that to the value of product sales in the relevant industries, and that shows that the stack of the royalty payments is somewhere in the low single-digit percentage of the value of the sales of the product. That obviously doesn't exclude that individual companies pay much more than that, and I think it's true, and I think there's evidence that individual companies pay much more than a single-digit percentage.
What evidence is that?
I mean, there were court cases where, they were able to show that a single company paid more than these 3% already for a single company, and in a larger standard with multiple portfolios. And it makes sense, it makes sense that if the average is 3%, then there must be some companies that pay less than 3%, and then there are some companies that pay much more than 3%. And I think if you're a company that has no own SEPs to cross-license, then already you would be looking at it more 3% than 3%. And then if you are maybe, your products are on the lower price side of the market, then probably your percentage is higher. And so you can make a list of considerations that determine whether a company would look at a higher or lower rate. And so I wouldn't be surprised if there are companies that end up paying 20% or something like this for particular industries. But then still the question is that a problem? Is that excessive? Is that driving implementation behavior away from these standards? And I think that's a really relevant question. And for that, I think the evidence is not in that we really see the delay in implementation or even complete non-implementation of valuable standards because of the concern over the royalty payments.
Tim, what do you think? Have you seen evidence of this?
I definitely agree that kind of as an empirical research matter, it's very challenging because this information is closely guarded. No one is, publishing their licenses on their website. And, as a lawyer who litigates these issues, I'm obviously bound by protective orders and the like, and obligations of confidentiality to clients. So it's hard to. I think it's on both sides of the debate about whether they're too high or too low, what impact they have. It's very difficult to reach an informed conclusion because the amount of information is limited. I do think Joseph made the point that when we've seen demands that have been made and then adjudicated by courts, we've seen a pretty big spread. And now, obviously, that's that got remedied through the court, by being able to go to court and have a court look at the situation and make a determination. But clearly, there's situations where people don't go to court, and those rates presumably get paid by some people. So I think there's reason to suspect that there is overpayment, that that the royalties are high. But I can't cite you to a paper. I can't prove it in any definitive way.
Well, we talked about one impact the law can have is on royalties, increasing or decreasing them. I think, Justus, you mentioned earlier, it could also be about incentivizing agreement between the parties or trying to incentivize them not to litigate. Do you think that right now the law, the way it's set up, incentivizes either implementers or patent holders to litigate?
So I think that litigation to some extent is healthy and to some extent is good and produces something that is socially valuable. It produces guidance, it produces information, it produces comparables. And I'm almost concerned about not there being enough litigation, because the litigation rate has not increased significantly. I think that the number of litigations is trending pretty stable, whereas the population of declared standard essential patents is increasing, and the number of industries that are using declared standard essential patents is increasing. So you can wonder why that is that we are seeing less of these disputes playing out in the open in the court system. And I think that in an ideal situation, access to courts would be fairly cheap, expedient, and people who have grievances with individual situations could get a quick resolution of their legal claims. And I think that would be a good thing. And I think that there's a little bit of this unfortunate rhetoric that people who are litigating are doing something evil. and that it's a symptom of abuse necessarily if people use the court system to have their disputes resolved. And the other thing, obviously, is the cost of litigation. I mean, if the litigation cost for a single dispute is in the millions, for many, many licenses, it's just not worth it. And in other countries, obviously, the cost of litigation is much lower, but I think that it's always in the hundreds of thousands. And there are many SEP licenses or possible or potential SEP licenses that just don't reach that threshold. And for these licenses, dispute resolutions through the court system isn't really an attractive or maybe not even a viable option.
Go ahead, Joseph.
Yeah, just building on that, I feel like a lot of the things that we're arguing about today are the same things we've been arguing about for 15 years, and like they're not really relevant anymore. Like, you know, since eBay, you don't really get injunctions anymore. You know, all the talk about hold up, that's not an issue in the U.S. And then you know, the issue of the royalty stack. You know, when I talk to businesses, you know, on the licensee side, you know, I don't hear complaints about the amount of the royalties as just the cost of the litigation. The litigations just become massively expensive, and there's so much of it, and there's no one to negotiate with. You know, even when patent pools come together, there's no guarantee that all the patents will be in that pool. Sometimes there are competing pools. Sometimes you license a pool and you think you're done, but there's just no way to, there's no resolution, and there's no, you know, given the number of patents that are proliferated and the number of suits asserting them, you know, the cost of the litigation for a lot of these folks is a much more significant factor than the licensing fees they ultimately end up paying.
Kurt?
I have maybe a couple comments too. Let me talk first about the royalty stacking issue. The problem with it is everyone wants to argue it's hypothetical. Like, if I pay you this, then my total burden is going to be Y, right? And the Erickson v. D-Link court dealt with this, and they said, look, implementer, you know, in evaluating the FRANdness of this offer, if you have, you know, evidence of a royalty stack on this particular standard, give me your evidence. And I haven't seen a case, even a district court case, where an implementer has put forth those type of evidence, and it's been in the published decision to say, you know, wow, there's a problematic royalty stack here. And then when you look at the real world evidence about royalty stacking, and I think Justus hit on this, okay, the amount of litigation, despite the proliferation of standards, is down in that if you normalize it across that. That suggests that the system of arm's length negotiation between parties is working. And yes, you're going to have an occasional dispute. And yes, you're going to have disputes among high rank or high profile patent holders and high profile implementers. Okay, and it gets lots of publicity. All right, but you know the standards keep coming. Every 10 years there's a new G. And there's ways in the standards bodies to punish people if you're believed to be someone who charges too much for your patents. You're just not going to get your patents in the next standard, okay? So when you look at the system as a whole in a holistic view, I don't think royalty stacking is anywhere close to a problem. It is literally the boy who cried wolf, in my opinion. And when you look at the health of the standards, 3G took a few years to roll out. 4G was quicker. 5G is getting rolled out even quicker. Okay, which means that the uptake of the standards is not affected by the royalty paradigm for that particular standard, at least from that type of qualitative view. So.
And do you think, Kurt, that the current state of the law incentivizes large implementers to litigate or to reach a deal?
I think that's a hard question. I think that taken to its extreme, there are incentives in place to hold out. But I do think that businesses want to reach resolution. Okay, they don't want to have disputes out there. They want to push on. They want to sell their products. And being in dispute posture is an incredible time suck for management and whatnot. So I do think though that if we get a paradigm with no injunctions, that we can just throw in a FRAND dispute without looking at the FRANDness of the licensor's offer, then you are going to drive more holdout behavior. It's by definition, okay? Businesses are rational, and if their downside is lessened, then they're going to go and implement those types of behaviors.
So do you all think that the standards organizations should play any role in trying to resolve this issue of what is FRAND, or do you think they're best just left to say, you need to be FRAND and go figure it out somewhere else?
I think in a perfect world, and maybe DVB, as we heard about this morning, is that perfect world. If the standard setting organization could reach consensus, but obviously that means consensus among all the members who have disparate interests, which is obviously a huge challenge. If they could offer more clarity, more guidance, I think that's probably only a good thing. I'm skeptical, though, that that there's necessarily a path to get there. Particularly for the cellular standards, I just think that there's probably too much ground between the various factions that reaching a compromise that everyone would support is probably an impossibility.
Yeah, I mean, it seemed like a key aspect of the DBV policy is the mandatory arbitration. Mm-hmm. And I wonder if any of you think that either side, implementers or patent holders, would be willing to agree to mandatory arbitration to settle their FRAND disputes on cellular.
When you get a relatively closed standard, sort of like the olden days when it really was a few companies negotiating a standard, then you can work out things like that. But a lot of these standards have just become very contentious. And I'd refer back to something that Earl Need said on the last panel. These SDOs, they want to focus on the technology, and they have they're not equipped to, and they have zero interest in wading into these legal disputes about how these issues should be resolved. I feel like it's been over a decade that people have been talking about, we should fix this through the SDOs. The SDOs don't want to do it, and we can't force them to do it. It's not their expertise, and bringing these politics and these disputes in would just roil those organizations.
Justus, what do you think?
Yeah, and one additional factor to take into consideration are these complex interactions. First of all, interactions between different standards organizations. So if one standards organization goes out and defines FRAND or creates rules for access to dispute resolution or whatever, then immediately that creates some kind of a disconnect between the rules for one set of patents under this standards organization's rules, and these same patents might be essential to standards in a different standards organization, or even the very same standard might be adopted by different standards organizations, and then you get kind of an overlay of competing and not necessarily consistent rules, which I can't really see how that would be efficient. And the other thing is that then you have by now a fairly thick body of case law and other instruments of guidance, like national governments have produced guidance and so on. And so there's a beginning of an understanding of what these words mean. And now an organization comes out and offers an additional explanation, additional words that, once again, they might differ from what a court in a particular, like the case law in a particular country would say. And either the court would then say, okay, I regard this as just fairly consensual and just a statement of what we already knew, which is kind of the benign case. Or the other situation is that they say, okay, it seems like this standards organization is trying to do something different. So it seems that this patent is no longer subject to a FRAND, but it's subject to FRAND 1 or FRAND 2 or FRAND 3 or whatever that organization calls it. And then the question is, does all this guidance that we have still apply? Can I still use it? Can I still use all these cases? Can I still use all these comparables? And I think that is really an outcome that you don't want to be in, that you kind of fragment the guidance, that you fragment the case law, that you fragment all the knowledge that is in the industry about how to negotiate a FRAND license by a standards organization, that you basically need a different set of norms, a different set of rules for every standards organization or for every set of SEPs. And I think that this is one of the takeaways from these back and forth with the IEEE patent policy, is that since there was no particular eagerness by other standards organizations to follow the example and to adopt similar language, at some point the discrepancy between the IEEE language and other organizations' language just became untenable, that they felt like if we want our standards to continue to go through ISO, if we want them to continue to be accredited as American national standards, if we just want to preserve our space in this very complex and interwoven ecosystem, then there needs to be alignment between what we say the policy is and what all these other organizations say.
Yeah, so I mean, you know, with the IEEE, they in 2015 passed a policy that would require, among other things, SSPPU as the starting point for licensing negotiations, and they've recently reversed course on that. Tim, what are your thoughts on kind of what drove that policy in the first place, and then why there was the reversal?
Well, I think they submitted a business review letter to the DOJ in 2014, I believe, explaining that they were kind of answering the call of regulators that SSOs step up and try to promote more clarity, try to provide more guidance to parties so that they go into it with a better understanding of the rules of the road. So I think that was the intention. I think it's a laudable intention, but as we've been discussing, I think there's agreement on this point that it's going to be hard for an SSO to have all of the members or enough members that it sticks agree on what those rules of the road should look like. And I think that since 2015, since the adoption, there have been licensors who have dissatisfied with the changes, who have worked very hard to undo them and succeeded to a certain extent. I mean, you can still, I think that the revised policy still allows you to consider the SSPPU. It doesn't mandate it. There's a change in terms of injunctions. They're not allowed necessarily against the willing licensee, but it's scaled back a little bit. So I think probably I think it started with good intentions, but I think it gets to the reality that Joseph was mentioning, that it's very hard to get this into place at an SSO. It's hard to reach something with enough detail that it's going to kind of change in any meaningful way how parties engage with each other about licensing, that's going to get enough buy-in to get passed.
Kurt, what do you think about that? I mean, what do you think was kind of driving the initial change to the policy and why it was reversed?
I think that the initial change to the policy, what happened was a few companies that had a very pro-implementer view were able to, sort of get the policy done in a way that wasn't really accepting of counter views of the particular issue, and it was political, and eventually it was like a 3-2 vote if I remember right, and so it had effects. Some companies stopped making FRAND declarations to that particular standard, the subsequent Wi-Fi standards that were worked on after the policy change. And I think one of the things you have to remember about standards is that most of the technology is offered by very few companies. I don't remember the last statistics, but if you look at the 4G cellular standards, I think it was like 65 to 70% of the technology was offered by 10 companies. And so you have few companies doing basically the R&D for the industry. And then if you want to implement a policy change that's not going to recognize that this is risky R&D, that this R&D is done years ahead before the standards are fixed, and there's no ability when you invest in it to understand whether the technology is going to be accepted or even if the standard is going to be successful. okay, you have to account for that in your patent policy, and that's really, I think, the beauty of the ETSI policy. You know, we need to protect innovators that are offering technology and make sure that once the technology is standardized, that they'll offer FRAND rates to those that are, you know, implementing fully conforming devices. So, and I think when you play with that balance, you're going to get unintended consequences. And here we are 7 years later, and IEEE has basically reversed almost all of those changes.
So, you know, one thing that we often hear from patent holders, and I mentioned it early when we, you know, in this discussion, is that if you change the incentives, you know, for example, by requiring SSPPU, that's going to reduce participation in the standard. You know, you mentioned that you saw a reduction in declarations for IEEE, but I'm curious if at Qualcomm, you know, you guys saw any reduction in participation or quality of the standard.
I don't know about that, and so, you know, we had a unique situation, and I don't want to speak for the company. I'm speaking for myself on this panel, so.
Yeah. Justus, any thoughts on that?
Yeah, I'm aware of at least 5 studies, I think, that have tried to measure impact of the policy change on different metrics of engagement with IEEE or contributions to IEEE standards development. And they come to wildly different conclusions, which I think is due to the difficulty of measuring engagement in the space. But more importantly, I think I'm not sure it was reasonable to expect that there would be dramatic changes in standards development behavior in this particular setting. First of all, because companies make their decisions to participate to a certain technology at a certain point in time, and then they invest, and then they sit on all this intellectual property and human resources related to this particular piece of technology. So they might, at that point, when they see, okay, the rules are changing, they might make a decision to say, okay, we're becoming less interested in this, but they will not stop contributing or stop participating the day after, just because they still have all this associated assets, you know. And the other thing is that many companies were in situations where they could at least claim to benefit from some kind of prior or blanket disclosure or whatever, so that they said, okay, we are still contributing under the previous rules. And then some companies might had the intelligent and rational foresight to say, this is not going to last, you know, like it's at some point the rules are going to revert back to what they were. And if people did make that calculation, apparently they were correct. And so, like, for all these reasons, I think it's just not a clean test. Like, we don't really know whether changing the rules in the general ecosystem in a way that is clear, it's clear that this is how the rules are going to be from now on, forever forward, and then give companies 10 years or so to adjust to these new rules and then measure somehow the impact of that. I think we don't know what that would be. And I don't think that the IEEE policy change told us what that would be, the impact, just because like there were so many idiosyncrasies here and so many things affecting participation behavior, and it's so difficult for companies to shift from one year to the other, all these very path-dependent investment decisions. So I think that there's a lot that we learned from this empirical work, but we did not necessarily learn what the effect of these rules changes on investment behavior would be.
So we've only got a few minutes left. I want to give at least opportunity for one question from the audience. Any questions? See someone? Can't see.
Hello. Great discussion. I was in the industry for 10 years, but I've been out of it for 7 years now, both negotiating SEPs and doing litigation. My question is, do you think that transparency on licensing as well as the patents and their applicability to various parts of the standards would be a big help here? Because it seems like that's the biggest thing that's lacking, and that would help prevent people on either side taking advantage based on their position.
I think if there was more transparency on licensing terms, I certainly think that could resolve a lot more disputes. I think often companies are, they're concerned that they think they're being asked to pay more than their competitors are, and they believe that that's unfair, and I think that's a reasonable position. If there was a way to have some insight into what those competitors are paying, I think you would see fewer disputes, because people would say, well, if I go to court and this is the evidence that's going to be used to figure out what I should be paying, and the evidence is that it's X, well, I'm going to pay close to X, because it's not worth litigating about. I'm going to only drive up my expenses. I think, as with the SSO policy issue we've been talking about, the devil's in the details. How do you do that in a way that people are going to be comfortable with, because people don't want to reveal their confidential licenses?
Anybody else on the panel on this question?
Just, same thing. I mean, transparency is nice as a goal, but this is very sensitive economic information for people that they don't, give up readily. And outside of a court adjudication where you have some way of guaranteeing confidentiality and trust, it's just going to be hard to get this, this kind of information out of people.
Okay. Last word, Justus or Kurt?
On the transparency thing, I think that it's usually always good. Information produces clarity and reduces frictions and so on. But obviously, almost all types of information are also costly to produce. So I think that there's some kind of market mechanism that also determines how much companies are going to invest in different types of information producing behaviors. And trying to mess with these determinations, or basically it's, as a central decision maker, as a government, say, okay, you have to produce at least as much, even though the market signal is that, okay, we are not necessarily seeing the value of that investment. I think that's kind of what's concerning me with some of this focus on transparency, where there's an assumption which is reasonable that information is valuable, but there's also an assumption that it's more valuable than it costs to produce. And that's, I think, something that you can't assume. That's something that you would need to assess very carefully.
Okay. Well, thank you very much to the panel. Thank you to the museum and the sponsors, and of course to Thane Bauz for putting this together. And thank you all for attending.
Before we close the 2022 Global FRAND and SEP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McKool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you to all of them. And of course, thank you to the executive director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.